We have to thank Herbert Smith Freehills to give us this lovely office to use. Thank you very much. Now, welcome remarks. Can I introduce Professor Lin Fin, based here from the City University of Hong Kong. He is the Dean, and also he's in charge of comparative law and Chinese law. You name it, relating to China, you ask him for expertise. Professor Lin.
Yeah, thank you, Chris. Yeah. Distinguished guests, colleagues, alumni, friends, ladies and gentlemen, good evening. On behalf of the School of Law of City University of Hong Kong, I'm delighted to welcome you all to the 30th Goff lecture tonight, whether you are joining in person or online. As I've been told, there are more than 500 people who have registered online. So welcome you all to this lecture. And first, I would like to extend my heartfelt gratitude to Herbert Smith and also the Hong Kong International Arbitration Center for their generous sponsorship of today's event. The Goff Lecture Series was established in 1990 by our school to commemorate the launch of the Master of Arts program in Arbitration and Dispute Resolution, which is now known as the Master of Laws in Arbitration and Dispute Resolution. The inaugural lecture was delivered by Lord Goff of Chivoli, a distinguished Lord of Appeal who graciously consented to lend his name to this series. The Goff Lecture has since become a prestigious platform for dialogue and exchange of ideas among practitioners and academics in the field of arbitration. And for today's lecture, particularly the choice of time is upon actually Neil's recommendation. The reason we choose today is because it's within the Vis East competition period. So we want, in addition to attracting local participants, and we also want to attract international participants to this lecture. And the register number shows the sort of that kind of attraction is there, and I'm sure many of them are attending online now. I would also like to take this opportunity to say a few words about the Master of Laws program in Arbitration and Dispute Resolution. It is the first specialized master's program of its kind in Asia, and it has for over 35 years provided lawyers and related professionals from Hong Kong, Chinese mainland, and beyond with comprehensive training in all aspects of dispute resolution, particularly on arbitration. The program's success over the years would not be possible without the support of professionals in the field, in Hong Kong, mainland China, and also overseas, including some esteemed individuals like Neil, Philip Yang, Rimsky, Christopher, and many others, as well as various arbitration centers like Hong Kong IAC, CTAC, SCIA, and numerous law firms support. Okay. Today, we are deeply honored to have Mr. Christopher Thomas, King's Counsel, with us to share his insights on the topic, the strange results that attend human life, the story of the Alabama claims arbitration. I will leave the detailed instruction of the speaker to my colleague, Chris Tavaleta, and I hope you will enjoy tonight's lecture. Thank you.
Thank you very much, Dean Lin Fin. Now, can we have Mr. Mock, partner of Herbert Smith Freehills, to give us some kind of remarks and also to thank him for his continued support.
Thank you. Good evening, everyone, and thank you for joining us tonight, both in person and online. Herbert Smith Freehills Kramer has long been a proud sponsor of the Goff Arbitration Lecture, and tonight we host the 30th in the series, and that is a remarkable milestone in itself. And we're especially honored to market with this distinguished speaker, Mr. Christopher Thomas, KC. Christopher is going to take us on a journey back to one of the most celebrated and I think one of the most intriguing episodes in the history of dispute resolution. At its core, the Alabama claims arbitration was a dispute driven by the collision of great powers. Now, the parallels with our own time are hard to miss. Geopolitics is once again driving disputes. The rules-based international order is under real pressure. So it feels particularly timely to look to history for guidance. And there are lessons here, not just for the states, but for commercial parties too, as they navigate what are likely to be some very choppy waters on the horizon. The Alabama claims also remind us where much of the modern arbitration began. Today, we take for granted the familiar features of the process: a standard arbitration agreement, a sole arbitrator or three-member tribunal, and a well-established procedural timetable. But as Chris's research shows, the Alabama claims arbitration departed from what we would now consider standard practice in nearly every respect. Understanding how far arbitration has come helps us chart the right course for the future. It also provides a useful lens for some of the current debates about whether arbitration continues to deliver the efficiency, the flexibility, and the procedural fairness that parties rightly expect. And with that, I will rightly hand over to Professor Christopher Toe to introduce Christopher.
Thank you very much, Mr. Mark. Now, ladies and gentlemen, it is my great pleasure to introduce tonight's distinguished speaker for the 30th Goff Lecture, Mr. Christopher Thomas, King's Counsel. A Canadian barrister and solicitor appointed by the Queen's Counsel in 2002, Christopher Thomas has built an unparalleled career in international trade and commercial law with a special focus on trade and investment regulations and dispute settlement. His impressive academic credentials include a BA, LLM from the University of British Columbia, an MA from Sussex University, and an LLM from the Columbia University. Early in his career, he clerked at the British Columbia Court of Appeal, taught at leading Canadian law schools, and served as senior policy advisor to the Canadian Minister for International Trade during the pivotal Canada-US Free Trade Agreement negotiations in 1986 to 1987. He later founded and led his own firm, Thomas and Partners, before transitioning to sole practice in 2009 as a preeminent arbitrator and mediator. From 2012 to 2018, he advanced legal scholarship as Senior Principal Research Fellow and Head of International Dispute Resolution Program at the National University of Singapore Center for International Law, while also teaching at NUS Faculty of Law. A visionary in the field, he co-founded Investor State Law Guide, the leading online database for investment treaty arbitration research. Christopher has acted as counsel in landmark GATT, WTO, and NAFTA and investor state cases, and now boasts an extraordinary portfolio of over 70 investor state arbitrations as arbitrator, spanning exit, anti-trial, PCA, ICC, SIAC, HKIAC, and more, including high-profile matters like Karen Energy, India, Glencoe, Colombia, Elliott Associates, Korea, and Anton and Spain. He serves as key rosters such as United States, Mexico, Canada agreement, and the comprehensive economic and trade agreement panels of arbitrators, and he has provided expert opinions and amicus curiae roles in courts from Canada to Singapore and Hong Kong. Recognized in Chambers Global and the international who's who of commercial arbitration, he has lectured worldwide at ICA congresses, ASIL meetings, and IBA conferences. Tonight, for this prestige lecture, Christopher Thomas, King's Counsel, brings his vast expertise to inspire us all. Please join me in giving a warm welcome to Mr. Christopher Thomas, King's Counsel, to give his speech. Thank you very much, Christopher.
Thank you very much for the kind introduction. Yeah, it's really a great honor for me to be here tonight to deliver this lecture for the 30th Goff lecture. And the City University of Hong Kong, the Hong Kong International Arbitration Center, and the various sponsors of this lecture series should be not only congratulated, but thanked for the continuing support, because this series, of course, serves as a tribute to Lord Goff. It's 30 years, I understand, since Professor Derek Roebuck had the idea of a lecture series of this type. And since then, it's been given by many distinguished speakers, far more distinguished than myself. And I'm really, truly honored to be included in their numbers. One of the great speakers, I understand, was Lord Bingham. And Lord Bingham, of course, not only was one of the greatest judges of the last century, he also happened to have an interest in the Alabama claim. And Neil Kaplan pointed out to me that when he was the president of the Institute, the Chartered Institute in 2000, Lord Bingham gave a speech at the Millennium Dinner at the Institute at the Guildhall in the City of London, which centered on the Alabama claims. So that created a certain amount of trepidation in me when I heard that from Neil. In any event, let's proceed. The title of my speech, "The Strange Results That Attend Human Life," is taken from the diary of the American arbitrator as the arbitration was nearing its end. It struck me that it's a rather fitting description of a strange, even bizarre arbitral proceeding. And I'll only be able to give you a sense of this tonight because this is an extraordinarily complicated dispute, not only in the actual conduct of the arbitration itself, but in the events leading up to the arbitration. There are stories upon stories embedded in this particular saga, but I'm going to give it a go in terms of giving a sense to you tonight of how this arbitration unfolded. Now, my interest in the case came out of a question that occurred to me when I first started to go to the Permanent Court of Arbitration in The Hague, where I had a number of arbitrations. And I was always wondering, what was it that led Andrew Carnegie to pay for the construction of the Peace Palace? He wrote a check in 1903 for $1.5 million. And that fundamentally underwrote the costs of the construction of the Peace Palace. And I wondered what it was that led him to do that. And it turned out that Andrew Carnegie's interest in international arbitration had been sparked 30 years previously in the Alabama claims arbitration. And as a result of the Alabama claims arbitration, the whole subject of international arbitration became an obsession for Andrew Carnegie. And he spent the rest of his life from 1872 until he died after the First World War, advocating for arbitration treaties between states. Now, when the representatives of 26 countries assembled in The Hague in 1899 for the first Hague Peace Conference, the result of their work was to establish the Permanent Court of Arbitration. And Carnegie was thrilled by that because it seemed to be the culmination of his dream of creating an arbitration treaties. 3 years later, Andrew White, the head of the US delegation to the peace conference, approached Carnegie to see whether he would underwrite the construction of the Peace Palace. And in a happy coincidence, while White was pressing Carnegie to pay for the construction of what became the Peace Palace, Carnegie was pressing President Theodore Roosevelt, who had been appointed to arbitrate a dispute between Britain, Italy, and Germany on the one side, and Venezuela on the other, to send the dispute to the Permanent Court. And so when Roosevelt acceded to Carnegie's importunity, Carnegie was again thrilled by this development because it was a validation of the PCA, and he wrote a check for $1.5 million. Now, there's another set of reasons, but I'm going to come to those at the very end of this presentation. So I wanted to understand, well, what was it about the Alabama claims that so intrigued Carnegie? And I started to look into this case, and I realized that this is the most fascinating legal case that I have ever had any exposure to. I'm going to ask you to bear with me because I need to give you a summary thumbnail sketch of the facts and then describe the treaty that sent the case to arbitration before we can get into the good stuff. But I will attempt to knit it all together as we proceed in this presentation. So let's turn to the facts. In April of 1861, at the very outset of the Civil War in the United States, the newly appointed president of the Confederate States of America, Jefferson Davis, issued a proclamation where he was going to issue letters of marque to privateers, which would then attack the American merchant marine. This provoked a very quick response from President Abraham Lincoln, and he ordered the US Navy to blockade the southern ports. Now, very soon after that, Great Britain, which had extensive commercial relations with both sides, both disputing parties, declared itself neutral in the conflict. The British proclamation of neutrality was not well received by the United States. It was looking for support, not neutrality. It also felt that the proclamation had been too hastily proclaimed, just weeks after hostilities had broken out. But it's beyond this, the real argument, the real concern that ended up animating this arbitration was the United States' belief that Britain had either been unwilling or unable to exercise sufficient diligence in the enforcement of its neutrality law. Now, the issue was acutely presented because the Confederacy was a slave-based agrarian economy. It had no shipbuilding economy. It had no ability to produce ships, and it had very few ships at its disposal when the war broke out. And so it looked to Britain to procure warships that could be then used to attack the merchant marine. Now, this individual is James Dunwoody Bullock, and he was the Confederacy's principal naval procurement officer. He was a former United States naval officer who had volunteered for this service. He arrived in Liverpool, which was then the shipbuilding capital of Britain, in June of 1861. And he was instructed to procure gunboats, but he had very strict instructions that he must not violate the English Neutrality Act. And the reason for that was that the Confederacy hoped that it would obtain diplomatic protection from Great Britain. And if it got it from Great Britain, the European powers would follow. It never achieved diplomatic protection from any other state. But that was the hope at the time. So one of the first things that Bullock did when he arrived in Liverpool was to consult a local solicitor. And given the significance of the question, that solicitor in turn retained two Queen's Counsel to opine on the issue. And this is an extract of the legal advice that Bullock received. And I can summarize it quite simply. The key point was this, that English law did not prohibit the construction and sale of a warship so long as the ship was not ready to engage in hostilities when it left British waters. The offense, as you see in the last part of the first paragraph there, was not in the building, but in the equipping of the vessel. So Bullock therefore did two things. First of all, he sought to obscure the identity of the purchaser in order to provide plausible deniability to the shipbuilder. But the second thing he did was to separate the vessel's construction in Britain and its subsequent arming, fitting, and equipping outside of British jurisdiction. Now, the first ship to leave Liverpool was called the Oretto, and it departed on March 25th, 1862. It left without any official hindrance because it was registered as a British ship. It was said to be owned falsely by a British national. It was commanded by a British master, and it had a British crew. The Oreto was later commissioned in a very remote part of the Bahamas as the Confederate steamship Florida, where it also received its armaments and then proceeded to cruise against the United States. In the case of what became the Alabama, it escaped from Liverpool on July 29, 1862, after Bullock received a tip from London that an enforcement order, a detention order, was likely to be sent to the customs authorities in Liverpool. 2 weeks later, it rendezvoused with two tenders just off the Azores, where it received its armaments, its crew, and its Confederate officers. Interestingly, the Confederate cruisers did not confine their activities to the Atlantic and the Caribbean, which is what I would have expected. In fact, they pursued the American Merchant Marine around the world and either took as tenders or sunk vessels in such distant ports or off of such distant areas as the Cape of Good Hope, the Strait of Malacca, the Sunda Sea, and the Java Sea, rather, in the Strait of the Sunda Strait, and the Bering Sea, where they attacked, one ship attacked the North Pacific whaling fleet of the United States. No Confederate cruiser ever called in at Hong Kong, but the USS Wyoming was sent to Hong Kong and used Hong Kong as a base to attempt to chase the various Confederate cruisers that were in the area. Now, I've discussed Bullock's handiwork. Let's turn to two other important players in this saga. The first is the United States' most senior diplomat in London, Charles Francis Adams, and his principal British interlocutor, the Foreign Secretary, Lord Russell. This is a photograph of both of them, with Adams on the left and Russell on the right. Adams was, in fact, the son and grandson of two American presidents, and he had been extracted from the US House of Representatives and sent by Lincoln to take up this posting after the outbreak of the war. One of his main tasks was to forward information to Lord Russell, information that he received from the Department of State or from Liverpool or from other places in the world pertaining to the activities of the Confederate cruisers. He would urge Russell to seize Confederate warships, and he would protest any insufficiency in the British authorities' response. As the losses of ships and cargoes mounted, he was instructed to demand compensation from Britain. And although Russell conceded that the British law, the English law, had been enforced imperfectly, specifically with respect to the escape of the Alabama, he refused to entertain the idea of compensating the United States. Now, British resistance to compensation would eventually weaken, but Adams never achieved an agreement to send the matter to arbitration. He returned to the United States in May of 1868, planning to enter into his retirement. His successor, however, Reverdy Johnson, turned out to be a very speedy negotiator, and in the space of a few months, he ended up negotiating what became known as the Johnson-Clarendon Convention, named after Lord Clarendon, the Foreign Secretary of the day. Unfortunately, the Johnson-Clarendon Convention pleased no one in Washington, D.C. And when it was sent to the Senate for consideration by the Senate Committee on Foreign Relations, a senator, the chairman of the Senate Foreign Relations Committee, Charles Sumner, spoke out against the convention on April the 13th, 1869. He sharply criticized Britain's conduct during the Civil War, and he then set out the losses that he contended the United States had suffered as a result of the depredations of the Confederate cruisers. He started off with the direct losses of ships and cargoes, which he estimated to be $15 million. But that was just the beginning. He also pointed out that the United States Navy had incurred expenses in the pursuit and capture of Confederate cruisers. Insurance premiums had gone up during the war, And many American vessels had been reflagged under the British flag in order to escape possible attack by the Confederate cruisers. But most importantly was the last head that I have identified there. He contended that by its unfriendly and insincere neutrality, Britain had allowed the Confederacy to extend the Civil War by 2 years. This was called the War Prolongation Claim. Now, Sumner's view was that since the United States had incurred a war debt of $4 billion, Britain was justly liable for half of the war debt. It was an astronomical sum. He was a little bit imprecise as to whether he meant half of the 4 billion or half of the remaining 2.5 billion that still had to be paid off. Either way, it was astronomical. Now, the real intention underlying this estimation of damages was to come up with an estimate of losses that was so large that the British would never agree to pay it. Because what Sumner's real plan was to get Britain to make a different form of compensation in the form of territory. And to understand this point, we need to take a look at the map of northern North America. At the time of Sumner's speech, British North America was a collection of 6 colonies and a massive tract of land. It's that light pink in the middle of the map, which was under the control of the Hudson's Bay Company. 3 weeks before Sumner gave the speech, the Hudson's Bay Company in Canada had come to terms on the acquisition of the Hudson's Bay Company's interests in what was called Rupert's Land and the Northwest Territory. Canada, as you can see in the very dark red of the map at the eastern part of the continent, was quite a small landmass at the time. There were only 4 provinces of Canada. 4 colonies had been made parts of Canada and became provinces of Canada. Now, the question that emerged after Sumner's speech was this: would all of the British North American possessions be assembled into a single country, Canada, as intended by Britain and Canada, or would they be annexed by the United States as compensation for the losses the United States claimed to have suffered as a result of the Confederate cruisers? Shortly after the speech, the British minister in Washington wrote to Lord Clarendon, "These people seem to have gone mad upon the subject, and their exaggerated pretensions are beyond belief. Most of the newspapers now speak openly of the approaching cession of our northern possessions on this continent as a fact which everyone has agreed." Indeed, a month before Sumner gave the speech, he wrote to a friend expressing some concern that President Grant's interest in the Cuban insurgency against Spain would detract or deflect the United States' attention from the real prize. And this is what he said: "I look to annexation at the north. I wish to have that whole zone from Newfoundland to Vancouver's Island, but a war with Spain would postpone this triumph indefinitely." Unsurprisingly, Sumner's speech was not well received in either Britain or in Canada. One American diplomat reported home that he had found much ill feeling in Britain as a result of the speech, and another one reported back that he thought that war was next to a certainty. But behind the violent public reaction in Britain were worries that if Britain became embroiled in a European war, the United States would take the opportunity to attack British North America. The Foreign Secretary, Lord Clarendon, expressed this view in a letter to Queen Victoria. "There is not the smallest doubt that if we were engaged in a continental quarrel, we should immediately find ourselves at war with the United States." Now, passions eventually cooled, and in January of 1871, after some inspired unofficial diplomacy between the two sides, it was agreed that there would be an establishment of a joint high commission that would address the Alabama claims and a number of other issues that were irritants between the United States and British North America. This is a photograph of the American High Commissioners. And the two people that I'd ask you to take special note of are the following. The Secretary of State, Hamilton Fish, who is seated in the middle, in the front row. And on the far right, standing at the right, is the Assistant Secretary of State, John Chandler Bancroft Davis. Davis would become the drafter, the principal drafter of the American case in the Alabama claims arbitration. And he would act as the agent of the United States in that proceeding. These are the British High Commissioners. And the two people to take note of initially are Lord de Grey, who sat in the middle of the front row, and Lord Tenterden, who was a senior Foreign Office official standing in the back row on the left side. Like Davis, Tenterden would be the principal author of the British case, and he would also act as the agent in the arbitration. There's one other individual that I want to identify, and that is the Prime Minister of Canada, who is standing with his arms crossed in the back row. Sir John A. Macdonald was rather diffident about being recruited to be a British commissioner because he worried that Canada's interests would be sacrificed on the altar of better Anglo-American relations. But he reasoned, as Mark Carney has reasoned recently in Davos, that it was better to be at the table than to be on the menu. And so Macdonald rather grudgingly made his way to Washington, D.C. Now let's turn to the treaty that resulted from their work. This is the arbitration agreement contained in Article 1 of the treaty. And it states that in order to remove and adjust all complaints and claims on the part of the United States, and to provide for the speedy settlement of such claims, which are not admitted by Her Britannic Majesty's government, all the said claims growing out of acts committed by the aforesaid vessels and generically known as the Alabama claims shall be referred to a tribunal of arbitration. Britain also expressed regret for the escape, under whatever circumstances, of the Alabama and other vessels from British ports, and for those depredations committed by those vessels. 3 rules of maritime neutrality that had been negotiated by the two states would act as the governing law in the arbitration. Now, the interesting thing here is that the British did not agree that the 3 rules that they had negotiated were reflective of the rules of international law at the time of the Civil War. And so they insisted on including an express reservation on this point in the treaty. But nevertheless, they agreed that these rules could be applied as if they did apply at the time of the events in question. And it would be put before a tribunal of 5 arbitrators, 2 party-appointed arbitrators, and 3 neutral arbitrators. Now, the procedure warrants some note. It was primarily to be a written procedure. There would be 3 rounds of pleadings filed simultaneously. And I want you to take note of that. That's a critically important agreement. The case would be filed on December the 15th, 1871. 4 months later, the counter case would be filed. And then 2 months after that, when the tribunal convened for the merits of the case, the argument would be filed by the party. The counter case was explicitly said in the treaty that it should be in reply to the other party's case. So although they were being filed simultaneously, the expectation was that the counter case would be responsive to the case filed by the other party. Also of particular note is that oral submissions were permitted only if the tribunal required further elucidation. So it was obviously going to be primarily a written proceeding. Now let's turn to the arbitrators appointed for this case. We'll start with the party-appointed arbitrators. Perhaps the most remarkable event in the entire arbitration was the United States decision to appoint Charles Francis Adams as their arbitrator. You'll recall he served for 7 years as the United States minister in London. He had authored almost all of the diplomatic correspondence complaining about Britain's application of its neutrality policy during the Civil War. When I reviewed the arbitration record, you can't really make it out, unfortunately. It's a little bit small on the screen, but I'll explain what this is. This is an index of the appendices that had been prepared by Great Britain after the pleadings had been submitted. And you can't make it out too well, but if you look at the far left column, the bolded lettering at the top is by whom or from whom. And but just below that is Adams, comma, Mr. If you go over 2 columns and you look at the date, there were 9 letters alone written by Adams in the month of January 1862, which were put into evidence in this proceeding. Hundreds of letters by Adams ended up in this proceeding. Now, President Grant was unenthusiastic about appointing Charles Francis Adams because of the history of the Adams family in the United States. But the American agent was very keen on this appointment, and he wrote to Secretary of State Fish the following: "Tell the president that the arbiter will be really senior counsel with the advantage of being inside the commission and hearing all the British objections there. And that Adams knows the case as nobody else can and can answer such points better than anybody else." Obviously, today, such an appointment would be completely improper, would never withstand a challenge. In fact, Britain's counsel at the time, Sir Roundell Palmer QC, was scandalized by this appointment. And he wrote to the foreign minister and he said, this is impossible. There's no way that we can get an impartial hearing from Charles Francis Adams. But the treaty did not contemplate arbitrator challenges. And thinking that Adams' partisanship would be so obvious to the neutral arbitrator, and that he in any event would be outgunned by the British arbitrator, the Foreign Secretary dismissed these concerns. Now, after Adams accepted his appointment, Davis asked him whether he would like to read the draft American case. Here's what Mr. Adams had to say in response to that. "I have already seen a part of your paper and have no objection to seeing the rest if you deem it advisable that I should. It could have little effect upon my own judgment, as I am so familiar with all the facts upon which it must ultimately rest that it is scarcely likely to vary very much." So, in any event, the 2 men met and they spent a day discussing the United States draft case. And then Adams wrote to Davis with some suggestions about matters that he might want to include in it. Davis later reported to Hamilton Fish that Adams also asked him whether the United States intended to give him any instructions as to the minimum gross sum to be insisted on in the arbitration. He evidently would like to close the matter up, and said Davis, and he thought that Adams wants somebody to share with him the responsibility of naming a smaller sum than the public have been educated to expect. So let's turn to the British arbitrator. He was a formidable looking individual, Sir Alexander Cockburn, the Lord Chief Justice of the Court of Queen's Bench. Cockburn seemed to be the perfect candidate. He was the son of a diplomat. He was a brilliant linguist, and Lord Granville, the Foreign Secretary, marveled at his command of all the European languages. His mother was, in fact, the daughter of a French aristocrat, and his French was said to be flawless. He was a man of many talents. He was, in addition to his prowess in French, German, Italian, and Spanish, he was a musician, a sailor. He was well known in literary circles. He was a close friend of Charles Dickens and Anthony Trollope, and he had a reputation of being a great raconteur. He started off his career as teaching at Trinity College, Cambridge, before becoming a barrister. He took silk, he was elected to Parliament, he became Solicitor General, Attorney General, and so as a former law officer of the Crown, he was knowledgeable of the rules of international law before he went to the bench. An indication of the British view of their arbitrator can be seen in a letter that Lord Granville wrote to Sir Roundell Palmer when he asked if he would accept a retainer as Britain's counsel. Cockburn has agreed to act for us. And Granville, I should have included another quote, but Granville's idea was that Palmer would travel to Geneva with Cockburn to supervise the statements and possibly to plead. Now, there's no evidence that Cockburn ever read or commented upon the British case, as Adams did in respect of the American case. But he had many, many ex parte contacts with counsel, agent, and the Foreign Secretary. In fact, when the merits phase of the arbitration took place in the summer of 1872, he lived on the same floor of the Hotel de Bergue as the British delegation. He had a Foreign Office person be appointed as his secretary, his private secretary in the arbitration. And he developed a bit of a tendency to reformulate British applications to the tribunal that were rejected by the tribunal, and he would reformulate them in a day or two as his own motions, but with not much success. But the real problem with Sir Alexander Cockburn was that he proved to be incapable of disguising his disdain for two of the three neutral arbitrators. And he let it be known that he thought that they were completely unqualified for the job. Well, who were these three neutrals? They were appointed respectively by the Emperor of Brazil, the King of Italy, and the President of the Swiss Confederation. All were legally trained, but two of the three had almost no practice experience. The Brazilian arbitrator, Baron and Viscount d'Itajuba, was Brazil's ambassador to France and had held diplomatic postings in Europe for many years. The Italian, Count Sclopus, in his early days had been a magistrate and a cassation judge, but he then entered into politics and academic life. The Swiss arbitrator, Jakob Stempfli, was a newspaper proprietor, a legislator, and a former president of the Swiss Confederation. Unlike more recent treaties, the Treaty of Washington gave no guidance to the appointers as to qualifications required of the arbitrators. And the disquieting consequence of this for Britain was revealed at the tribunal's first meeting on December the 15th, 1871. It turned out that two of the three neutrals, the Brazilian and the Swiss, were unable to read or speak a word of English. The Italian, Count Sclopus, became the presiding arbitrator, and he professed to be able to read it, but not to speak it. But the parties soon found that his grasp of written English was rudimentary, to put it mildly, and therefore the proceedings would have to be carried on in French. Davis had anticipated this possibility, and he had arrived in Geneva with a French courtesy translation of the United States case. The British had not, and they were immediately put on the defensive. With only 4 months between the first pleading and the second pleading, they were now facing the task of having to translate the pleading and the voluminous exhibits that they had assembled for this case. As Davis reported home, this gives us an enormous advantage, as the English translation is not yet ready. Stempfli and d'Itajuba don't understand one single word of English spoken or printed. Count Sclopus reads it with fluency, that was incorrect, but speaks but little. We therefore have the field to ourselves for the present and must inevitably get our side of the story into the heads of the neutral arbitrators before the British. Now, this was not a problem. Having a proceeding in French was not a problem for Sir Alexander Cockburn. But he was shocked to discover that his three colleagues were not capable of carrying on the dispute in English. He was a famous stickler as a judge for procedural fairness and the rights of the accused. And in this case, he worried that the pleadings and the voluminous exhibits that had been assembled so meticulously by his country would be impenetrable to the neutral arbitrators. Adams privately agreed with Coburn that this was an undesirable situation, but he remained silent the next day when the tribunal reassembled. And at that second meeting, Sir Alexander Coburn attempted to convince the neutrals that they should resign from the tribunal. They refused to do so, and they seized on the various expedients that he had listed, such as the need to translate every document. He said this would be very burdensome. They said actually it would be very helpful. And so they refused to resign from the tribunal. The second issue with respect to their qualifications was that there was only one that had any experience in judicial proceedings. That was Sclopus. And his judicial experience was dated. He took his appointment very seriously. All of the arbitrators did. But Sclopus was, well, he was a very dignified a man of social graces, and he was very diligent. He proved to be indecisive. And it didn't help that the brilliant and increasingly irascible Sir Alexander Coburn started to turn his fire on him. Now, the next unpleasant discovery for the British side was this. Actually, I'll get back here, sorry. Yes, sir. Oh, I've got the wrong button here. Forgive me. You'll recall that Charles Sumner had estimated these massive indirect and consequential damages. During the treaty negotiations, the two sides had discussed what claims could be put before the tribunal. The British informed the United States side that they had no instructions to treat on what they called the wild claims of the prolongation of the war, as an example. And the key point for tonight's purposes is this. By the end of the negotiation of the Treaty of Washington, the British High Commissioners were convinced that the American commissioners had waived the indirect claim and that the treaty did not permit the claims to be brought. This is what they reported home during the negotiations and what they said to Parliament when the treaty was being considered by Parliament. When British ministers and officials finally got around to reading the United States case in the beginning of January of 1872, they were not only taken aback by its very aggressive tone, but they were stunned to find that the United States had incorporated Charles Sumner's indirect claims into its damages claim. Both sides knew that Sumner had sought to arrive at a figure that Britain would never agree to pay. And they knew that the losses had been conjured up in order to extract territory from Britain. But now that Britain had submitted to arbitration, the claims had now been brought as part of the United States case. Everybody could do the math, and it was soon realized that Britain's financial exposure could be north of £1 billion. An enormous uproar ensued in Britain. William Gladstone's ministry was put on the defensive, and the British High Commissioners were put into a very uncomfortable spotlight. One London newspaper called them imbeciles and fools. A former Liberal minister, Lord Westbury, sprang into action. And in the beginning of January, he wrote to the Foreign Secretary saying that you must refuse to participate in the arbitration so long as the indirect claims are preferred. Granville forwarded Westbury's letter to Sir Roundell Palmer for his view. And Palmer agreed with Westbury that nobody in Britain would have been willing to go to arbitration upon such claims and advanced upon such grounds if this case had been seen beforehand. And he took very strong exception to Adams' appointment calling him the US advocate in the tribunal itself. And he queried whether the three neutrals were actually lawyers. To make matters worse, and this is not well known, this is something that I came across in some correspondence. It was not widely publicized at the time, but right around the time that Westbury wrote to Lord Granville, the Belgian ambassador to London informed Granville that the Belgians had picked up a rumor that the Americans had bribed the Swiss arbitrator. The rumor spread with the political cognoscenti, and it grew in its retelling to two arbitrators supposedly gotten at by the United States. And a very, very deep panic set in. The leader of the opposition, Benjamin Disraeli, who chose not to make this a partisan issue. There was no dissent in the House of Commons when this issue arose. There was a tremendous coalescing of all political parties. He wrote to the conservative member of the Joint High Commission, Sir Stafford Northcote, a very, very dark letter. And Northcote, who was now feeling personally exposed at having negotiated the Treaty of Washington and seen what had happened in the arbitration, was aghast. And he said in reply to Disraeli, if there are grounds for doubting the honesty of the arbitrators, the matter becomes very serious. All these considerations, however, are subordinate to my mind to the great and unpleasant one, that we have been deceived. Whether deceit was intended from the first, or whether it was an afterthought, or whether we deceived ourselves, may be a question, but we, the negotiators, most distinctly understood that the claim for indirect damages was waived. And unless we had felt assured of this, we should not have agreed to arbitration at all, much less to arbitration under ex post facto rule. Alexander Cockburn, for his part, felt no restraint in commenting on this situation. And he wrote to Westbury, and he said that it was clear to him that Britain had intended not to submit the indirect claims to arbitration. But instead of taking the precaution of expressly defining the limits of the inquiry, they have left the terms of the treaty quite large enough to embrace any claim, however preposterous and remote, which bold and unscrupulous politicians may have the effrontery to put forward. It was the extreme of imprudence to trust to the good faith and honor of the people they were dealing with. The stakes were raised a couple of days later when William Gladstone rose in the House of Commons and said that it would be insanity for Britain to participate in an arbitration where these claims were being made. And he said that Britain would not participate in the arbitration if the United States insisted on preferring the claims. But withdrawing the claims because its opponent didn't like them would have been political suicide for the administration of Ulysses S. Grant, because he was up for re-election in 1872. It would be a national humiliation for the United States to withdraw these claims at the British request. And indeed, Secretary of State Fish, he took the position that the United States had not waived the indirect claim. It would take 5 months for the two sides to make their way out of this morass. Now, Fish initially professed nonchalance at the response in Britain, but many other Americans, Andrew Carnegie included, and other business leaders, began to become very nervous about the outcome of this arbitration. And they began to petition the administration to find a way to abandon the indirect claims. Meanwhile, Charles Francis Adams engaged in an extraordinary set of meetings after this took place. He was traveling back to the United States, and he arrived in London en route to Liverpool the day after Gladstone's fiery speech in Parliament. And after consulting the American minister in London and one of the US legal counsel, he decided to engage in what I've called arbitral diplomacy. And he met with 2 British cabinet ministers over the space of 2 days, and then later with Sir Alexander Cockburn, to try to convince them that he did not think that the United States really meant what its pleadings said. In meeting with Lord de Grey, who you'll recall was the leader of the British delegation, after stressing the unofficial character of what he was about to say, Adams expressed his private opinion that the vague claims had been preferred to complete the view of all the transactions, and he did not believe that the US government meant to press the matter upon the tribunal. Sorry. Oh my, this. When he finished his meetings in London, he also added, I think that was going quite far, I should read this, but I'm quite clear that all our counsel, and most of all Davis, would spring at once to save the treaty. Now, after he finished his meetings in London, he made his way to the United States. And when he arrived in New York, he telegraphed Secretary of State Fish to ask whether he should go to Washington for consultation. And Fish asked him to do so. So he did that. And at their first meeting, Fish convinced him that the United States view of the tribunal's jurisdiction was the correct view. And Adams seemed to accept that, at least at that point. He then helped Fish formulate a response to Lord Granville's letter to Fish, expressing concern at the United States bringing the indirect claims and insisting that they did not fall within the jurisdiction of the tribunal. And the following day, he met with President Grant and his cabinet to discuss the crisis. He then returned home to await instructions as to whether he should be going back to Geneva and whether there would be an arbitration to go back to. Things were looking very grim. In fact, he did receive instructions. And after 2 months of his staying in Massachusetts, it was time for him to go back. The United States government had told him that the United States would be in Geneva, represented in Geneva on July 15th, whether the British showed up or not. But he also received the Treasury Secretary of the United States, George Boutwell, who was sent to see him by President Grant. By this time, the United States was very concerned that the arbitration was slipping away and that the British were implacably opposed to the indirect claims, and that the arbitration, which was a great foreign policy success for the Grant administration, would be at naught. Grant instructed Boutwell to tell Adams that, and this is the letter of George Boutwell back to Hamilton Fish, it is the view of the President of the United States that it is in the interests of the United States that it should not prevail on the indirect claim. This must be the rarest of things for a party to inform an arbitrator that it does not wish to succeed on a particular set of claims. Adams was also instructed to convey this message to Cockburn and to any other senior minister that would listen to him in Britain. But the British were not going to be satisfied with oral assurances. May and the first 2 weeks of June went by, and there was still no resolution of the indirect claims. Finally, when the tribunal reconvened on June 15th, the British agent informed the tribunal that he had the argument in hand, but he would not file it because Britain was applying for an 8-month adjournment of the proceeding to allow the parties to engage in negotiations and finally get rid of the indirect claims. None of the arbitrators wanted an adjournment. And so what happened next was another extraordinary development in this case. They had to solve a problem of jurisdiction. The United States was very clear. It was prepared to have the claims dismissed, but it wanted the tribunal to first take jurisdiction. Britain would not accept even a negative finding on the indirect claims if the tribunal purported to exercise jurisdiction over them. And Cockburn told his colleagues that he would have to resign because it would fall outside his grant of powers as the British arbitrator. The claims were ultimately disposed of by what the tribunal called an extrajudicial declaration. It dodged the question of whether it had jurisdiction or not. And it simply said that in any event, the claims were not well founded in international law. Now, since this was not a formal ruling of the tribunal, because Coburn could not be a party to a formal ruling, it had to be an unofficial declaration of its opinion. And the tribunal therefore had to call upon the parties to see whether they would accept this opinion. The parties did, and the indirect claims controversy was finally disposed of. Now, the wrinkle in this part of the proceeding was this. The tribunal's declaration was written by counsel for both parties over a period of 4 days. It was then taken by Charles Francis Adams and presented to Count Sclopus, who then read the declaration out to the party. The American counsel team then provided a legal opinion recommending to the president that the opinion given by the tribunal, which had been written by counsel, should be considered to be dispositive of the claim. And the president accepted that. Once the president accepted it, the British accepted it. And so for the rest of the summer, the only claims that the tribunal was concerned with were the direct losses of ships and cargoes, and this other claim of the US Navy for the costs incurred in the pursuit of the Confederate cruisers. Now, there was a problem, though, unfortunately. 2 problems arose as soon as the indirect claims were disposed of. The first was this: Sir Alexander Coburn had traveled to Geneva believing that the arbitration was coming to an end or it would be adjourned for 8 months. And he hadn't read into the case. And so rather embarrassingly, he had to apply for an adjournment for 2 weeks so that he could study the case. As Lord Tenterton rather dryly put it in a report to Lord Granville, the Chief Justice was imperfectly up on the facts and argument. The second problem was this. This is a chart that shows the length of the parties' pleading. The page lengths of the first 2 rounds of the pleadings can be compared on an apple-to-apple basis because I took them from the reprints of the pleadings that were submitted to Parliament. Note the astonishingly short US counter case, 11 pages. It was so compact that it was published on the front page of the New York Times in its entirety after it had been submitted to the tribunal. The counter case declared that the United States considered it unnecessary to discuss all the propositions of the British case which were regarded as disputable or requiring further argument. And this was very odd language for a pleading that, according to the treaty, was supposed to be in reply to the case filed by the other party. But the effect was startling. By the end of April 1872, Britain had sought to rebut the American case at length, but the US had barely tipped its hand as to its view of the British case. That came when it filed its 495-page argument, including 65 pages of supplementary notes, on June 15, 1872. The problem from the British perspective was that in addition to the length and the articulation of the case in the argument, new material had been adduced and new arguments were being made. And the British considered that they had been sandbagged by the United States. So Palmer therefore wrote to opposing counsel to propose a supplementary briefing schedule, and this was rejected. So Palmer decided to raise it with the tribunal, and this is what happened next. This is according to one of the private secretaries of the US legal team. The upshot of the affair was that at the request of Mr. Davis, a memorandum was drawn up by Mr. Cushing, one of the counsel, and translated into French, giving the reasons why no further argument of the nature contemplated by the Council of Great Britain should be permitted. This paper was put into the hands of Mr. Adams. When Britain made its application, Adams spoke against it, and the tribunal rejected the application. A disgruntled Palmer returned to London for 2 weeks, while Coburn began to furiously read into the case. Now, when the tribunal reconvened on July 15th, 1872, with no witness testimony and no oral submissions, the question was, what should the tribunal actually do? And the answer was that it decided that it would proceed through the case on a vessel-by-vessel basis in front of the parties and their agents. So each arbitrator would read out a provisional judgment in front of the parties. I can't imagine doing this in front of the most critical and knowledgeable audience possible than the agents and counsel of the parties, but that was what they agreed to do. And of course, it's unheard of in modern arbitral practice, where deliberations should be kept secret. But it provided great moments of drama and for the two sides, particularly for the Americans, because it soon became clear that the United States was going to prevail on at least some of the vessels. Now, the tribunal proceeded in this fashion on the first vessel, which was the Florida, and provisionally determined by a vote of 4-1, predictably, that Britain was liable for the acts of the Florida. Sir Alexander Cockburn became very restive during this process because the four other arbitrators had arrived at the same conclusion through completely different analytical means. And unfortunately, Mr. Schempfli in particular had misstated the evidence. And so Cockburn believed that these four separate opinions couldn't possibly stand together. And so he suggested that the tribunal should follow his earlier suggestion that they should hear submissions from counsel on the meaning of the treaty and discuss the meaning of the treaty amongst themselves before they determine the fate of any particular vessel. This was rejected, and he turned on his colleagues. This is Charles Francis Adams' diary. He asserted that persons who had never been in any position to be acquainted with the law were under a peculiar obligation to stand ready to learn. And he carried on in the most defensive manner. Davis reported to Fish, there are men here not educated in the law who are now examining questions about the great laws common to nations for the first time. It is impossible that they should not be benefited by the help of counsel. This did not go over well with his colleagues. And realizing that he had offended them, he tried to beat a retreat, but his apology he bungled. It might well be that those who thought they know the most might in fact be less conscious how little they know, was his apology. The tribunal was unmoved. But 3 days later, Sclopus and Dita Juba changed their mind. They were worried that the arbitration would go off the rails. And Sclopus told the British agent in an ex parte meeting that he regretted the difficulty that had arisen with respect to oral argument. And so he and Dita Juba convinced the other two arbitrators to allow Britain to file a reply to the US argument, and then to allow the US counsel to comment on that. And the way this was done is that Mr. Dita Juba called upon counsel for further elucidation. Clearly, this was done to diffuse the British objections to the fairness of the proceeding. And as far as I can see, it made no difference whatsoever in the overall disposition of the case. Now, the strange list of arguments and occurrences in this arbitration goes on, but I'm going to have to stop at this point and just wrap this up. In the end, the tribunal awarded damages of $15.5 million in favor of the United States. Cockburn refused to sign the award, and he tabled at the last minute, completely unbeknownst to his colleagues. He had spent the summer writing a long, separate and dissenting opinion, which is actually very well written. But Britain announced that it would honor the award. And so despite its many oddities and infirmities, the Alabama claims arbitration in the result turned out to be a success. It had resolved an extraordinarily contentious and fraught dispute peaceably. And this stimulated an upswell in interest in international law and arbitration more generally. And it's no coincidence that within months of the award being issued, the International Law Association and the Institut de Droit International were formed to promote the study of international law. So, why did Andrew Carnegie write a check for $1.5 million? What was at the root of his obsession with the Alabama claims? And it turned out to be this. At the end of the US Civil War, Carnegie had become a very wealthy man, and he had started to spend the summers in Great Britain with his wife. During the summer of 1871, in the afterglow of the Treaty of Washington, and what appeared to be the dawning of a new era of favorable relations between the United States and Great Britain, as a kind of a hobby, Carnegie took a trunkload of bonds for railway companies and bridge construction to London to sell them to financial houses. The US market was saturated, and so he brought along this trunk, and as a kind of a hobby, he managed to sell $1 million worth of bonds in the summer of 1871. In 1872, when he went back to Britain with another trunkload of bonds, the indirect claims crisis had caused immense financial distress. American securities had plummeted on the London market. No one was willing to touch American bonds, and this included sovereign debt. The United States was attempting to refinance its Civil War debt in London, and no one would touch the American bonds. It had to be called off. When it was reported that the indirect claims crisis had been resolved, investor sentiment improved. But it was not until after the award was issued and Britain announced that it would honor the award that Carnegie was able to sell another trunkload of bonds. And he became convinced in his experience that this process was the antidote to war between sovereign states. And for that reason, he became a great proponent of international arbitration for the rest of his life. And that is why he wrote a check for $1.5 million. I'll end with one other small anecdote. This one I was really quite interested to discover. As I mentioned earlier, it was Theodore Roosevelt's decision to send the Venezuelan claims arbitration to the PCA that had convinced Carnegie to write that check. In a very strange twist of fate, James Dunwoody Bullock, the architect of the Confederacy's ship procurement program, which in turn gave rise to the Alabama claims arbitration, which so captivated Andrew Carnegie, was none other than Theodore Roosevelt's Uncle Jimmy. Thank you for your kind attention.
Well, thank you very much, Chris, for that amazingly interesting lecture. It's so nice and reassuring for us to know that sandbagging and guerrilla tactics have a long and ancient history and are not part of modern, necessarily modern arbitration. I just want to ask you this. It took, Great Britain had a year in which to pay the debt, right? Was there any talk in the press about not paying at all?
Surprisingly, no, there wasn't that much. There was grumbling. And the main reason for the grumbles was that there were principally 3 vessels that were found to have engaged liability for Britain. The Alabama, the Florida, and a vessel called the Shenandoah. And the British felt very badly treated by the tribunal on the question of the Shenandoah. And so the damages, of course, would have been proportionately lower had the liability not been found for that vessel. And so there was a bit of grumbling about that. They thought that the decision of the tribunal was completely wrong, and they felt quite badly about it. But Gladstone saw this. Again, I used the phrase, the price of peace. And Gladstone saw this as something, it was a necessary payment that had to be made. And they were so relieved, I think, having escaped the indirect claims crisis, that even though the damages award was higher than they expected it to be, they were prepared to pay it. And there wasn't really a lot of outcry in Britain for this.
Okay, so they had a year to pay. This was before income tax, I think, wasn't it? So where do they get the money from?
from the national budget. It amounted to 5% of Britain's national budget at the time. So this was not an insignificant amount of money. In fact, I've got a slide. Oh, it's already passed on. But anyway, let me see if I can go backwards. Roy Jenkins, who wrote a biography, a very good biography of Gladstone, and he, of course, had been the Chancellor of the Exchequer, tried to calculate it in the early 2000s, and it came out to roughly equivalent to 160 million pounds sterling at the time. But in relation to national income, it was more like 4 billion pounds sterling. And in relation to the size of the budget, the equivalent of a modern 150 billion pounds sterling. So this was not small change. The damages actually were, the 15.5 included interest rate at 6%. And so when you backed out the interest rate, it came out to a damages award of about 7.5 million. Coburn said that he would award damages of $4 million. And as it turned out, Coburn's number was closest to the amount of money that the United States government turned around and distributed to the claimants in the United States, the insurance companies, the shippers, the cargo.
I think Johnny V did it at the present day value. What did that come to?
You know, I haven't got the number at hand, Neil, but I know. Oh, you've got it at hand. Johnny extrapolated it to present day equivalent of US $225 billion at 5% of Britain's budget.
So given all that, I mean, I'm quite surprised that there wasn't an outcry in the press about paying so much money.
I think that when they considered the alternative, which was war, I think that people believed that this was the appropriate thing to do. It's interesting to note that when the indirect claims, I was quite struck by this, when the indirect claims issue arose really in earnest at the end of January, beginning of February 1872, Gladstone asked for estimates of the troop size of the United States Army. And almost at exactly the same time, Fish sent a telegram to the American minister in London asking whether or not Britain was activating its troops to send troops to Canada. So it gives you a sense of just how fraught this dispute was between the two countries. And I think there was tremendous goodwill that had been created in the Treaty of Washington. And I think the British came out of that negotiation thinking, well, we've pretty well settled this and we're going to have to pay some money, but it's not going to be a huge amount of money. But everything was turned upside down when the indirect claims were.
Of course, 1872 was the time of war, wasn't it, with the Franco-Prussian War going on?
It was over. It was over in 1870. It started in September of 1870.
Right.
Or it's September of 1870. But the French were soon defeated. Germans were occupied.
And of course, a few days after the opening of the Peace Palace, the First World War broke out.
Yes. And this was a terrible thing for Andrew Carnegie. Carnegie had really, and actually there's a small footnote on this as well. When the Archduke Ferdinand was assassinated, the Austrian government demanded the right to enter Serbia and investigate the circumstances of that assassination. The Serbians refused that, but the Serbians offered to send the matter to the PCA. And this offer of arbitrating this dispute was rejected by Austria, which declared war, which then triggered all of these interlocking treaty relationships in Europe and threw Europe into World War I. And Carnegie was devastated by this. He really did believe that states had kind of turned a corner and were now much more prepared to engage in peaceable dispute settlement between the Alabama claims and various other arbitrations and the work of the PCA. And he turned out to be wrong.
Has anyone got any questions? Anyone like to ask anything?
A couple of $1 million. I'll show you. On the island. Yes. When he sold his conglomerate in 1901, he was thought to be the richest man in the world. And he entered into this intense period of philanthropy, building libraries all over the world, etc. And he was never able to give away, he wanted to give away his fortune. He never got close to giving away his fortune because of interest. So the Carnegie Foundation still actually administers these funds. Yes.
How do you assess the prospects of Carnegie's vision coming to fruition at some stage?
Of whose vision?
Carnegie's
Carnegie.
vision.
Carnegie. Okay. Well, it's a fraught topic these days.
You need to give a pre-Trump and a post-Trump answer.
And it may be that the post-Trump effect may take longer to work out than we all think. I mean, the United States right now, and its attitude towards international law, is a kind of a piecemeal, reactive kind of attitude. It focuses on specific issues and rejects them. Whether it's the idea of tariff bindings, which were all agreed in the NAFTA and the Canada-US FTA and the WTO, when states agree to reduce their tariffs, they bind their tariffs against future increases, except in very narrow circumstances. That was thrown out the window. Has that idea of tariff bindings been rejected by the world at large? No, because outside of the United States, there are a vast array of free trade agreements and other treaties where tariff bindings have been maintained by the states party to those treaties. So this is as my prime minister called it, a rupture, but it's a rupture which is uniquely tied to a hegemonic power that has traditionally been the architect of these types of agreements. And that's the great irony of it, is that the United States, and believe me, the idea that the United States was ever suckered in negotiations by countries like Canada and Mexico is preposterous. Nothing ever got done in these negotiations without the United States signing off at the end. So it's a complete illusion to suggest that US negotiators were somehow seduced or misled or suckered by other negotiators. That's just not the fact. Will this come back? I wouldn't be surprised if it does, but I also think that the trouble is once you begin to reduce tariffs and you enter into a kind of a ad hoc commercial policy, vested interests become built up. The United States steel industry is very happy with the Trump tariffs. Why not? 50% tariff on steel coming from Canada. They're making money hand over fist. The consumers of steel are not so happy in the United States. But it's a complicated area. And the problem with the way in which tariffs are being administered in the United States is it is building in constituencies that will resist attempts to go back to what was once normal commercial policy. But I don't believe the rest of the world is following into the rupture. I really feel that the rest of the world is kind of doing what it can to deal with this unpredictable environment while simultaneously trying to enhance and increase their treaty relationships with parties that are in a similarly affected situation. A long way away from the Alabama Plains.
Yes, a question over there.
Thank you. Quick question. So I understand the broad theme of your research is showing us that we might question the integrity of the arbitrations. And if that's right, what can we say now about the jurisprudential value of the awards that come out of the arbitration? Because I seem to remember in my own research, you sometimes, reference is made to these awards. It's kind of, pioneering pieces or pioneering jurisprudence in international law. But from everything you've told us now, I have a completely different perspective on it. So interesting to hear.
Well, it's a key point, and it's really, I didn't have time to get into this, but it's really important for us to recognize that it's wrong to hold these people to standards that now are deeply embedded in the way in which international arbitration is conducted, including at the state-to-state level. And so it, in a sense, it's like the ex post facto application of the three rules. It's wrong for us to go back and say, well, the Alabama Claims Tribunal was procedurally wrong and misbehavior on the part of the arbitrators. I think that these were all honorable people who were acting in accordance with what they thought was appropriate behavior at the time. I mean, some of it is truly shocking from a modern perspective, but that actually really shows us how far we've come in arriving at relatively common and agreed standards and guidelines as to arbitral conduct and as to conduct of counsel. So I think we have to consider the Alabama Claims Award in the context of the environment in which those arbitrators were operating. They were given no guidance in the treaty. You can't fault the appointing authorities for the appointment of people who couldn't speak English because they weren't told that they had to speak English. And that was a failure of the states party to the treaty. But what we see in subsequent treaties is we see more attention being paid on the question of qualifications of arbitrators. And of course, much more attention is being paid to the way in which the arbitration should be conducted. So you can actually use the Alabama Claims Arbitration as a teaching tool to just drive home how fundamentally different now international arbitration is than it was at the time. That's 150 years ago. We have to take that into consideration. And frankly, when you look at the award is very short and it does provide some reason. But from a jurisprudential perspective, there's not a lot in it. It was really a very kind of, they breached Rule 3, and therefore, and I mean, the Alabama escaped. It was negligence. I couldn't get into this, but the story of how the Alabama got out when legal advice was being sought by the foreign secretary is itself a lecture in itself. It's a shocking story of how they were unable to get a legal opinion, the foreign secretary saying that the Alabama must be detained. So the British did try, and in fact, they stepped up their enforcement over time. So I think when you look at the award, you just had to say, that was 1872. Now we're here. And it's an interesting award, really, because it demonstrated that an incredibly difficult and controversial issue could be decided by 5 arbitrators, 3 of which probably didn't understand the facts of the case all that well.
It's fair to point out, isn't it, Chris, that in America today, some arbitrators still are recognized to be advocates of the party who appointed them. So
yes,
there's this thought.
Well, that's also, if you want to, you have to avoid making generalizations. But when I talk about state-to-state arbitration, I think, for example, the Mauritius case between the Chagos Islands case between Mauritius and the United Kingdom, for example, and there's a very good decision there on the whole question of whether Sir Christopher Greenwood, then a judge at the ICJ, could sit as a member of that tribunal. And it canvasses the law very well. But you could go to The Hague and take a look at the Iran U.S. Claims Tribunal, and boy, how many unanimous decisions do you think there have been at the Iran U.S. Claims Tribunal history of that?
None.
Anybody want to take a guess?
None.
Okay, my information is a little dated. It's out a few years. 1. That was from one of the members of the tribunal. It's been a situation where every single case of any significance has been decided by the neutral arbitrator. And do you think there's communications between the United States delegation and the American members of the tribunal and the Iranians and the Iranians? I think there probably is.
Interestingly, between the Iranians and the Americans.
Well, that's why they maintain the tribunal. It's a conduit between the two countries.
Well, I think we better call it a day. Thank you very much. Or the other Christopher will say something.
Okay, thank you, Mr. Thomas and Mr. Kaplan. Now, in terms of the closing remarks, can we have Ms. Lau, the Secretary General of the Hong Kong International Arbitration Center, to give her the closing remarks in terms of this lecture series? Thank you, Joy.
It's really a pleasure to be here, a milestone year for the Goff Lecture, the 30th edition of the Goff Lecture. And I really have to thank Christopher and Neil for delivering this very engaging and thought-provoking lecture. In particular, for me personally, I have a few observations. One is I think Christopher really brought to life the background and the characters to the Alabama claims. It's almost like we were in the hearing room going through the process together. And I particularly appreciated the fact that Christopher took the time to dig out the original documents, the original quotes. Fascinating, really interesting. I think the Alabama claims nowadays, it's praised as a symbol of success for international arbitration, but just hearing sharing the twists and turn, it could easily have gone the other way. And hearing how the process and the expectations or the actual procedural fairness, how different it is to today, but ultimately it was a successful arbitration. I think it prompts a lot of reflection as to what exactly are the essential elements of arbitration, which would result in a successful outcome. Things like arbitral diplomacy, or maybe it's a mixture of arbitration and mediation. I think these are questions that me, myself, and maybe many in the audience would go back thinking about for a long time. So thank you so much. And just to add a few more words of thanks, HKIAC is delighted to be co-organizing this year's Goff lecture with City U School of Law. So we express our sincere appreciation to the City U Hong Kong team for this collaboration. Thank you very much to Herbert Smith Freehills Kramer for their continuous support as exclusive sponsor of this lecture series. And of course, very warm thanks to all the audience members here, especially those who have traveled from overseas, some of them participating in the this East. So we very much look forward to welcoming everyone again at next year's Goff lecture. And just to finish off, HKIAC again is doing the Hong Kong Arbitration Week later in the year, 19th October to 23rd October. So the dates have been fixed. So really encourage many of you to come. So with that, thank you, everyone. Thank you again.
Thank you, Ms. Lau. On that note, can we thank Mr. Thomas again for his wonderful lecture, and also Mr. Neil Kaplan for moderating the whole session, and also all our supporters here, as well as the sponsors of this organization. Thank you very much.